Hi, today we will be discussing why you need to have a will and the importance of having one. Let's start with the basics. What exactly is a will? A will is a legal document that outlines how you want your personal assets to be distributed after your death. All your property and possessions at the time of your death is referred to as your estate, and that will be divided as per your wishes outlined in your will. Examples of what could be part of an estate include your personal belongings, property, money in bank accounts, proceeds from insurance policies, shares, etc. Anyone over the age of 18 can make a will provided they have capacity to do so. In New Zealand, there are three entities who can prepare a will, and that's lawyers registered with the New Zealand Law Society, trustee companies, or yourself. Wills can be commonly prepared by lawyers or trustee companies and held by them for safekeeping. These are professional bodies. Alternatively, you are totally entitled to make the will yourself. However, I do not recommend a do it yourself job if your assets are not modest or your family relationships are not in order. Examples of this include being remarried, having one or more companies, having properties with different entitlements, or if you believe there are family members who may contest the validity of your will. Why do you need to have a will? Well, the law in this area is dynamic, and that basically means that it could change at any time. At the time of your death, the law that exists will apply. If we compare this to you having control over what happens to your estate, a will allows you to do exactly that. The will allows you to outline what you want to happen when you die. What happens if you die without a will or without a valid will? Then you will be referred to as a person who has died intestate, and the intestacy laws will apply. The law in this area in New Zealand is the Administration Act. What the law has is a hierarchy of recipients, and based on relationships, that is how your estate will be distributed. Now, in the instance where a person has attempted to make a will, but it wasn't completed or it wasn't completed correctly, then an application can be made to the High Court to validate that will under the Wills Act. Another instance is if you did make a valid will, but it only covered part of the estate. In that case, the will apply, but for the remainder of the estate that is not covered by the will, the intestacy laws will apply in that instance. What we will run through now is a couple of scenarios. The first instance is where you have a spouse or partner but no children. Your whole estate will go to your spouse or partner. If we had the opposite situation and you've only got a child or children, then your whole estate will go to them only. If you've got more than one child, then the estate is divided equally. If you've got a combination, you've got a spouse or partner and children, the spouse or the partner is catered for first. They will get all of your personal chattels. They may get a sum of money, and that sum is calculated, and that calculation is outlined in Section 39 of the Administration Act. And that's for money for interest on legacies charged for land or chattels. Then the remainder balance of 1/3 will also go to the spouse or the partner. The child or the children will get the remainder 2/3 of the balance. If you've got a spouse or a partner and parents but no children, the difference in this situation compared to the previous one is that the parents get a smaller cut of the pie at 1/3. instead of the 2/3 that the children were entitled to in the previous situation. As you can see here as well, the spouse or the partner gets a greater chunk of the estate. If you've got no spouse or partner, but you've got parents, then the whole estate will go to your parents. Provided they do survive you, it will be divided between them. If you've got no spouse or partner, no parents, no children, but you have siblings, then again, to keep it within the family line, your whole estate will go to your siblings in equal shares if there is more than one. If your siblings do not survive you, then their share will be passed on to their children. If you've got no spouse, no partner, no parents, no children, no siblings, but you do have grandparents, uncles, and aunties, then this is a scenario that's going to apply. Half the estate will go to your mother's side of the family and half to the father's side of the family, so your grandparents get catered to first. If they are not surviving, then their share passes on to any aunties and uncles in equal shares on that side of the family tree. If they are not surviving, then if they have any children, then their share will pass down to their children. If you have no surviving family and no one else in your family tree that you can give your estate to, then what happens under the law is your whole estate will go to the New Zealand government, and that is the last stop. So what is the information that goes into a will? Remember, the aim is to express your wishes about what should happen to your body, your estate, and any dependents if you were to die. I'm just going to run through a few common clauses that are used in wills should you wish to prepare any will by yourself. The first point is you want to revoke or void any earlier will or any document where you have outlined any intentions if you were to pass away. You want to make it really clear that this document is the final document to use. The next point there is you want to appoint one or more executors. These are people who will be responsible for administering your estate after you die as per the instructions in your will. For example, they will pay any debts, deal with your body and funeral, and distribute your estate. This can be any person who's over the age of 20 with capacity, or it could be a trustee company. You want to choose people here who can be objective and who can act impartially in the role. I would recommend a family member or a friend. Now just remember, for the executors, it's not a paid role unless you provide for payment in your will. The next point there is about any funeral arrangements. You may have any ideas or wishes about this. For example, do you want to be cremated, buried, have a ceremony? These may not be strictly binding, but it really gives the executors some ideas on what to do. The next part there is about donations of body parts to research or for medical use, for example, an organ or tissue donation. If you have views about this, you may want to make this really clear in your will. The next point there is about who is going to benefit from your estate. These are people called beneficiaries, and this can be a person or an organization. What you want to do here is you want to make these clauses quite vague. A lot of people, when they're drafting their will, they write about what they currently have and not about what they could have in the future. For example, if you have one vehicle at the time of preparing your will and you say, I give the vehicle to my niece, but at the time of your death you may have 5 vehicles. If you don't account for the other 4 vehicles since writing your will, and that's not covered by your will, then remember the law is going to step in. So what I recommend doing is keeping the clauses quite broad. You could say, I give all vehicles at the time of my death to my niece. The next point there is if you have any children, then you may want to appoint a testimony guardian. And these are people who will care for the child or the children. You may also want to note any wishes or directions, for example, if you had a desire for them to go to a specific school. Now, please note that a testamentary guardian does not have the automatic right to provide day-to-day care for the child. To do that, they still need to make an application to the court for that. However, if you put that intention into the will, that may strongly support their application. And the last thing there is if you have any pets or animals, you may want to put who will take care of them. What I put at the bottom there is an example of how to write names in the will. You want to put the full name, and I would also recommend putting the city of residence and the occupation. And what that does is that it eliminates any confusion if there was a contest. So, what are the things that you need to keep in mind that could make your will invalid? Well, the first thing is that your will must be in writing. It cannot be an audio or a video. While those may show intention, the law does require the will to be in writing. The second point is it needs to be signed by you and 2 witnesses. Now, these 2 witnesses cannot be beneficiaries of your will. They have to be 2 other people, and they have to be over the age of 18. What you want to do here is you want to have the full name of the witnesses together with their city of residence and their occupation. Now, a little tip here is I highly recommend that both you and the 2 witnesses sign at the bottom of each page of the will document. This will help protect against the argument that any pages have been inserted after it's been signed. You also want to have a statement in your will that you have completed this at a time when you've had legal capacity and that you do intend for this will to be your final will. Now, just keep in mind, you may make a will that doesn't meet these requirements, but it's still able to be declared valid. But to do this, there is going to be a cost involved. Someone needs to make an application on your behalf to the High Court, and a judge needs to make a ruling on the balance of probabilities that your will is valid. Who holds your will? If the will is prepared by the lawyer or the trust company, then it's usually held by them and a copy given to you. If the will is prepared by yourself, then you are going to be the person that holds the copy. Now, please keep in mind that in New Zealand, there is no national register for executed or finalized wills, so it's really important that people know where your last will is kept. If you are preparing the will by yourself, then I recommend keeping it in a safe place, but also giving it to close family members or beneficiaries so that people are not scrambling around to find your final will in your passing. How is the will administered? The will come into effect by a process called getting probate. To do this, the executors of your will need to apply to the High Court of New Zealand to get the will formally approved. Now, little tip here is that there may be delays before everything is finalized and distributed. So if you have a partner that's financially dependent on you, you want to account for them during this delay period. And there's a really easy way to do this. If you get joint bank accounts or jointly owned property, then if one person dies, then the surviving joint partner will receive the property automatically. For example, money in joint accounts. The surviving joint owner will become entitled to all the money. Same with the property. Another little tip here is that there is something called the small estates rule where no probate and no application to the High Court is required. To do this, you need to have under $15,000 in your bank account. Everything else in your will be materialistic, so this just deals with the money. If it's under the $15,000, then your executor can just go straight to your bank, show them the will, and get the money there. If you've got more than $15,000, there's another option of opening another bank account with another bank and having under $15,000 in both bank accounts. There are benefits to having the small estates rules apply. Firstly, there's no court cost in applying to the High Court to get probate. And secondly, the money is accessed a lot faster, which means your family members are going to get it. Now, the best case scenario is that no one challenges your will and your estate just gets distributed as per your wishes. But unfortunately, this is not always the case. Wills can be challenged. They can be challenged for validity, or they can also be challenged by people who were given something in your will, but they think they deserve more. Or maybe there are people who didn't get anything from your will and they think that they should have. So in these cases, your will may be challenged. Common arguments for making a will invalid are that maybe it wasn't witnessed in the proper way, it didn't meet the requirements of a valid will, the person didn't have capacity, or maybe the person was under some undue influence and therefore prepared the will incorrectly. I'm just going to run through 3 common scenarios where the will is challenged. The first one here is by a family member. They can challenge the will on the grounds that they were not adequately provided for, or perhaps they weren't provided for at all. An application is made under the Family Protection Act 1955. The second one here is when you've made a promise to someone that you will provide for them in the will, and in return, they have given you work or services, and you've not kept your end of the promise. So they can make an application under the Law Reform Testamentary Promises Act 1949 in that situation. And the last situation there is about relationship property. Your spouse or partner can apply under the Property Relationships Act 1976 to receive half of the relationship property if they were not joint owners with you and they are not satisfied with what's been left. So they're not legally entitled to it, but they're arguing that they are based on the relationship that you had with them. I'm just going to run through examples of how clauses in the will are written should you wish to actually prepare the will by yourself. The first line there is the statement that's used in wills. It's the first line that goes in the will. It's a declaration that this is your last will. You put your full name in, your city, and your occupation. Now, please remember, if you were to amend your will, you cannot use an existing will and amend it and re-sign it. You've got to prepare a brand new will each time. The second statement there is again another declaration that is saying you are voiding all prior wills and this document that you're making will be the final version. And the last statement there is about the executors. You want to put their full name, their city of residence. What I recommend having here is having 1 or 2 executors. I also recommend putting a backup person. In the event that the first lot of executors don't have capacity or they don't survive you, you've got a third person who can step in and again protects your estate being divided according to the laws. The next lot of statements here is about wishes and your intentions around how you want to distribute your estate. So the first example there is about a wish about what you want to happen to your body or your remains. And all you say is the line, I express the wish, and you add what your wish is. The next example there is about gifts. You can outline as many gifts as you want. This can be specific or vague. For example, it can account for what you currently have or what you will have with the vehicles example. So you want to write the statement, I give my, outline what the gift is, and outline who you are giving it to. You may want to put a statement here as well. If that beneficiary is not alive, then do you want it to go to anyone else or does it stop there? And what we've got here is after all the gifts have done, all the debts have been paid, basically you come to something called the residue of your estate. That's just the balance, that's the remainder. What happens to all of that? Now, there's so many different ways on how you can do it, and it's completely up to you. I've used an example here where I've broken that balance into 4 equal shares and I've divided it among 3 people. One person is getting 2 shares and the other 2 are just getting 1 shares. You could divide it in as many shares as you want. Another example is using percentages. So you could say, you give 25% to this person, 10% to this person. It's up to you how you want to do it. I've also added in a clause at the bottom there to say that if those people are not alive at the time of my death, then basically their share goes back into the pool and gets divided among the remaining people. You could alternatively keep it in the family line, and you could say that if they don't survive you, it could go to their spouse or their children to keep it in their family line. But it's really up to you what you want to do. Just make your intentions very clear. And that's the presentation on wills today. I hope it's been informative and I hope it encourages you to get a will, even if it means preparing your own.